Morning, good afternoon, good evening, wherever you are in the world. Welcome to the Corporate Jet Investor and this week, the Helicopter Investor Town Hall. If you're watching live, please feel free to ask questions. We'd love to have you up on stage discussing the issues that you're already seeing. And if you're listening on the podcast, welcome. This took place on Friday, the 7th of March. So by the time you're listening to it, it could all be completely out of date. We've got three experts. We're absolutely delighted to have them, and I'm going to ask them to introduce themselves first. First up, Jonathan Epstein. Jonathan, we're really pleased to have you because you are both an aviation attorney and a trade attorney. But do you just want to explain how you ended up in those fields?
Yeah, it's kind of an interesting thing, but I do a lot of work, just the way my practice developed. I do a lot of trade-related work and compliance work for airlines, aircraft leasing companies, in addition to doing transactional work in the corporate jet space. So, and I've had to become do a crash course on USMCA, as I'm sure we all have, in the last 24 hours.
Brilliant. And Tobias, you're an expert on importing aircraft to the US, aren't you?
Well, TVPX Inc. is a licensed U.S. customs brokerage. So we are importing and exporting airplanes nearly every day in and out of the U.S. And we've been actively engaged in that business since 2018 when we started it.
And Ehsan, it's great to have you because you're giving us the Canadian perspective. And I know you're excited because this is a chance for you to add 25% to all your bills.
That's right. Yeah, that's how it's going to work. We do a lot of aircraft transactions and regulatory work, and so this impacts many of our clients, those with Canadian manufactured aircraft, but also those with aircraft manufactured in the U.S. and elsewhere could be impacted depending on where this escalates to. And so that's where this has really come up. And with Jonathan and Tobias, we've been sharing notes for the past month and a half and going back and forth and trying to figure out how to navigate this for the industry. So pleased to be here. And we know some of the answers. We don't know all of the answers. So for everybody, this needs to be taken in the context of what is available to us today at this moment and possibly within a 3-hour window. So we don't have it all, but yeah.
Okay. Tobias, do you want to take us through what's actually happened this week?
Sure. Well, why don't we back up a little bit because obviously the first threat of tariffs happened a little over 30 days ago. In fact, I was on my way to CJI London, and I thought this is going to be the big, topic of the conference. And before the conference even started, we had the first pause. And so at midnight, before the conference started, we had 30-day reprieve, and you asked me to come up and say a few things. So we talked sort of a little bit about, the customs import process, and we can certainly touch on that if you want to. And then we sort of talked about, what could have happened and what might happen. Fast forward 30 days to this week, and the tariffs went into effect for a day, basically. And of course, we've been getting lots of phone calls and questions, and there's a lot of misinformation out there, unfortunately, and misunderstanding. So hopefully we can dispel that. Mm-hmm. And now we have another pause until April. And so the question is, well, what happens, in April after this current period? And we're now at a point where, there are transactions that people are involved in. And that's probably the biggest problem, is that there are people who have entered into agreements to buy airplanes that are likely subject to the tariffs. And so what do they do? Just to back up a little bit, we're talking about importing aircraft into the U.S. that are being purchased for consumption in the U.S., brought into the U.S. for repair, and you've got to make entry through U.S. Customs, and it's a formal process. Goods need to be brought in under bond. The government wants data and statistics. And, for the past several decades, we've basically been operating in a duty-free environment. And that's changed, and so the industry needs to adjust and adjust very quickly. If the tariffs are going to apply, we're going from an environment where, we get a customs bond. It's a $200 premium for a $50,000 bond to cover a $632 merchandise processing fee. I mean, it's the fees were capped, and that number changes a little bit here and there. Generally goes up a little bit from time to time, but now we're looking at 25% tariff potentially on Canadian manufactured goods, aircraft in our world, obviously. And some of the questions I've been getting are, we're working on a transaction. It's a U.S. manufactured airplane coming from Mexico. The buyer wants to walk away. Is that going to be subject to the tariffs? And the answer is no. And what people need to understand is the trigger for the tariffs is the country of manufacturer, not the country of where it's coming from. So that's a big source of confusion. And I've answered that question. I've lost count in the last week or so. We've got an airplane, European manufacturer, coming from China, if you will. No, that's again, country of manufacturer is not subject to the tariff. It's Canadian manufactured goods that were the issue until the recent pause. One thing that I don't think people realized is that it's not just new, it's used. So, if you were buying a Canadian manufactured aircraft that's coming from, say, Europe, it was going to be subject to the tariff if it's imported into the U.S. for consumption, repair, and so forth. So that was the problem. Now we have this pause, and the issue is, what now in the next 30 days? What now after that? And
I think that's really important. So, Jonathan, you've read USMCA. There's definitely a pause for aircraft now.
Well, yes, but just to be clear, the 25% sort of tariffs that were implemented are still in effect. But yesterday there were the announcements. The president signed some orders last night. This morning, if you in the Federal Register, I guess they'll be published on the 11th, but you can look at the actual customs notices that went out this morning. In effect, if historically aircraft enter duty free, and you would never claim duty free treatment under the U.S. Mexico Canada agreement, the free trade agreement. Now you will do it if you meet the requirements for conforming goods under the USMCA, if the goods are originating in Canada or Mexico. And fast forward, yes, you get there on aircraft, you get there on aircraft engines. I'm not sure the analysis gets a little more detailed when you start talking about parts of aircraft or parts of engines. But we could walk through, but essentially, even if you had a Canadian-made aircraft with, German-made engines, those German-made engines would go through a tariff shift. And so under the rules of origin, under the USMCA, you could import them. And now the key issue is going to be the certification process, because it's a different process than the aviation industry has ever had to deal with before. And I think, Tobias and I have had numerous conversations in the last 24 hours on exactly this issue: is how do you certify? Will the manufacturer provide you the either the manufacturer, the exporter, or the importer can make the certification. The exporter or the importer will have to make it based on documentation. We're hoping that the manufacturers will make those, will be able to make those certifications, or at least provide support so that somebody bringing in a used Canadian aircraft can make that certification to customs.
Yeah, and let's just make sure everybody understands what that means. When an aircraft comes into the U.S. and we make the electronic entry in the automated commercial environment, there's a whole bunch of information that has to be provided. And there's one checkbox, which is yes or no, which is, are you making the claim that this is conforming to USMCA? Now you will check yes. And if you are checking yes, that sends a message to U.S. Customs that says, okay, where is the backup?
Yeah.
And there is a form that needs to be provided by the certifier, by the importer, certified by the certifier, that says, this is the certification that this conforms to USMCA. We've been operating in a duty-free environment for decades, as I mentioned, and I'm not sure anybody really has thought about whether aircraft are qualify for USMCA eligibility. So this is an issue that needs to be worked out.
Including the manufacturers, right? So like Bombardier is looking at this internally because they, for decades, as you mentioned, have been operating under the World Trade Organization agreement on the trade of civil aircraft. And that's where the duty-free treatment comes in. And the other problem that it exposes, this approach of does this qualify under USMCA, is that parts for aircraft come from all kinds of different places. And so now you could be in a situation where, let's just park the importation of the aircraft into the United States issue. But if you are an owner of a Bombardier aircraft or Canadian manufactured aircraft, or you are an owner of a non-Canadian manufactured aircraft, but you need parts that come from Canada, if those don't qualify under the USMCA treatment, those also get treated this way. So that's also going to disrupt the supply chains for getting parts to aircraft.
So just to step back for people who haven't been following this closely, the president's announced tariffs a month ago. They came into effect on Wednesday, and then yesterday. Jonathan, can you just explain what USMCA is to people who aren't experts?
So it was an agreement, and it was put in place during the last Trump administration and replaced the previous North America Free Trade Agreement, with the idea of, equalizing, allowing for fair trade across the borders. It sets, particularly in the automotive space, it sets requirements for, that certain amount of the content, the wage, the people manufacturing have to have a certain wage. It deals a lot with agricultural products. In other contexts, and for the most part, and not in some cases, it requires a regional value content calculation. So if you look at, and it was phased in starting in 2020 on cars. So cars that are, or car parts or cars that are made in Mexico have to have a certain amount of regional content, and so they can't use, third country parts, or they can only use a certain percentage. So it is a free trade. I mean, it's been NAFTA, I think, has been good for the U.S., Canada, and Mexico. I think the USMCA only, sort of improved on that. But historically, in 1979, there's this civil aircraft trade agreement was put into place. U.S. and Canada are signatories, and so essentially, the tariff codes that you normally import aircraft and aircraft engines in are duty free, and there was this procedure even if you were bringing in something that would otherwise be subject to duty, there was a mechanism for claiming duty-free treatment. I don't want to get into details, but just to be clear, the 25% tariffs are still in effect, and there might be products that fall outside, particularly in the parts world. but you can now, and my research over the last 24 hours really is that an aircraft or an aircraft engine should qualify. And I mean, if people want, I can walk through that analysis. It may be a little too technical, but happy to do it. I tried to lay it out in a couple of points.
So I was looking at
but the USMC certification, from a process perspective, that certification should be included in the import entry, and that's going to be the issue the challenge that as an industry we have to figure out in the coming days.
So sorry, Tobias, take us back on that.
Okay, so if you're checking yes that you qualify for USMCA treatment, there's a form that needs to be provided. Now, technically, it does not need to be included in the entry, but when you check yes, U.S. Customs is going to want to see the certification. So you might as well just provide it with the entry, because it sends up a red flag and they're going to want to see it. And, you know, if you're sitting on the ground in Bangor, Maine, you're going to sit until they resolve the issue. So that certification, I think the best practice is to include that with the entry, and then they see yes, they see the certification, and then they clear the aircraft, and you go on your way.
But the only one who can provide that is Bombardier or Bell would have to give you that information, because I think one of the interesting factors is that a large global Bombardier aircraft has more US content than Canadian, but it still counts as a Canadian manufactured asset. Does anyone want to comment? Yeah.
Yeah, I mean, the wings for the Global 7500 are produced in the United States. A lot of the major components are. And so it's just assembled in Toronto now. So, yeah, the final, Jonathan, you have to jump in here. What is it called? The most significant alteration, or the
substantial transformation.
Substantial transformation of the asset happens in Canada, and so therefore it gets treated as a product of Canada. And so some people were questioning in the chat, I saw, so the tariffs still apply, and the only exemption to them now for the next 30 days is on the basis that the product qualifies for USMCA. And that's where we need the certificate. And our understanding so far is that is something that would be issued by the manufacturer. And so the manufacturers in Canada are looking at how to do that and to support the products in market. But that still doesn't protect other products that might get caught, other parts in particular, that wouldn't benefit from that level of support, and that aircraft would need to avoid being AOG.
So something like an avionics, a major avionics piece that could be made in Montreal might not have that part. So let's do the really cruel thing where I'm going to start asking you specific questions, which is the last thing any of you want. But are we convinced this applies to all? Actually, so in theory, this is the month to import. If you're going to import an aircraft, you want to do it now. You want to do it before April the 2nd. Does everyone agree with that?
I would say we've all seen since March or since the beginning of the new administration, that things come and go. The actual CPP notice and the order that was signed last night by President Trump doesn't have that April 2nd date that was announced, but we have to assume that that's the case, although, yes. So I think there is a window here where if you had a transaction, this would be a good time, subject to, jumping through all the regulatory hoops to get that aircraft or aircraft engine into the United States.
But it still needs to qualify under USMCA. You still need the certification,
right?
And we may still need that certification in 30 days, after April 2. Now they're talking about reciprocal tariffs, so that's going to be another issue in 30 days. What exactly does that mean? I don't want to speculate, but I think it's that USMCA certification that's going to be the challenge right now, even in this month.
Okay, and sticking with questions, all three of you believe it applies to pre-owned aircraft as well as, so if it's a 1980 Bell coming in from Mexico, it still applies. Oh, sorry, Mexico is a bad example. Coming in from Brazil, it would still apply.
If the country of manufacturer is Canada, yes.
Yeah.
Okay, here's a question from Wendy Preston, a really good one. Does a sale of a used N-registered Challenger to another US buyer incur a tariff?
It really
Was it?
I mean, I guess the question is are you importing it into the United States for consumption in the United States? So if the aircraft is a seller in Kansas and a buyer in Tennessee, the aircraft's already within the customs territory of the United States. There's no import, there's no tariff. I guess in theory you could have an unregistered aircraft sitting outside the United States where you need to permanently import it because it's being imported for consumption to be based in the United States.
Okay, and Tobias, if I'm an owner of a Bell or a Bombardier aircraft and I'm outside the States and I want to bring it in for maintenance, I have to import it.
You should import it for repair and alteration. There's a tariff code for that. And I would suggest, and I think you'd probably bring it under a TIB, which is a temporary importation bond. And the difference now is a TIB, pre-tariff, the liability was the merchandise processing fee, which is capped, as I mentioned, at $630 and change. Now the tariff applies, and that amount has to be covered by the bond. So the underwriting for that bond is a different process now. The surety is going to say, okay, well, customs will say that, a bond is, if you have a bond now, it's a $50,000 bond at a $200 premium, that's going to be insufficient if there's a multi-million-dollar tariff that applies. So the surety is going to want to look at financials of the importer. They might want a letter of credit. So it's a process, that's going to take some time to get the bond amount up to an amount that is sufficient to cover the tariff in the event there's, a liquidation of that bond. And then you got to follow the rules of the TIB, which is, the aircraft can only stay in the U.S. temporarily for a year. The goods can't be sold. It's got to be exported. The TIB's got to be canceled. I mean, it's a process that's got to be managed very carefully.
Maybe I'll just jump in here too, because in this process in the last month and a half, we've had clients and industry contacts that we had to clarify, importation for customs purposes is not the same as importation from a regulatory perspective or registration perspective. So in the example that you mentioned, an unregistered aircraft, like that aircraft could be based in Isle of Man or it could be parked in London. The registry itself is not indicative necessarily of the status of it having been imported or exported into the United States in particular. And so going back to the question of, would I recommend getting aircraft imported now? Yes, and that was what we did before the tariffs came in and through the 30-day pause. The difference now being that we don't have the right paperwork to facilitate qualification under USMCA at this point. And the other thing that I want to raise for everyone to consider is that availability of space for even just doing heavy maintenance or doing pre-purchase inspections has now will become more contested both outside of the United States and within the United States, because this adds an extra layer of compliance burden that somebody has to go through. And so there was an example here, one of the chat commentators, Greg Miller, mentioned of a Canadian registered aircraft being sold to a Brazilian buyer. If the aircraft was imported at the time of entry, which it should have been when you're selling an aircraft that's closing in the United States, even if it's not going to be based in the United States, then you're fine. If it wasn't, then there was a potential issue with the importation to begin with, and so and that's something that either aircraft brokers or aircraft owners who are trying to figure out where they're going to close their transactions, where the pre-purchase inspections are going to happen. All of that is going to be impacted with the additional volume of compliance that's just been brought into the industry in the last 30 days. So
So going to Greg's question, he says, I'm currently working a Lear 40XR registered in Canada. The buyer is Brazilian. Closing will be in the US in April. Any words of caution? Any words of Jonathan? You nodded.
I would want to really think that through, whether you want to close in the United States. I mean, I guess you'd have to really think that through. I mean, do you permanently import it because it's going to be there's going to be a transfer of title in the United States under USMCA and then re-export it? But I would want to think that through. I mean, I know a lot of transactions that don't otherwise have a U.S. nexus normally close in the U.S. because you're bringing it in to an MRO for the repair, for the inspection, and there's good tax treatment for closing in a lot of U.S. jurisdictions. But I think going forward, people will have to think about the extra paperwork and risk associated with that.
But generally speaking, and this is something that I've tried to debate with the U.S. Bureau of Statistics with Tobias, whether it's necessary when the sale isn't to a U.S. resident, even though the aircraft's being inspected and closing in the United States. And every time the answer I've gotten is yes, it is necessary. You have to do it. And so sometimes for clients that seems unusual and they're uncomfortable with it. Now, what this imposes is an actual financial cost as opposed to just getting a top-notch customs broker like our friends at TVPX to help us with implementing and importing the aircraft to facilitate the closing.
Yeah, right. And to that question, right, I guess you could look at whether you could bring it in under bond because it's going to be re-exported under the TIB bond and then re-export it. But as Tobias said, that may raise issues. So, yeah, I don't know.
You can't sell. Yeah, sorry to interrupt. You can't sell goods imported into the U.S. under a TIB. So that's and that was always the problem before with TIBs. People would use TIBs to bring an aircraft in for maintenance, and then they said, "Geez, let's just sell the plane," and now your hands are tied. So you got to be very careful with that.
Okay, so try and close it in Canada is basically the advice.
David Hernandez is making a good clarification. So the country of manufacture does matter. So for the Learjet products, they might be manufactured. I think most of them are manufactured in the United States. So that will matter, but that's a separate point than what we're raising about just the requirement to import in order to close a transaction in the U.S. That would apply to any aircraft, whether or not it's Canadian manufactured.
Yeah, sorry, David Hernandez's very good question is that a Lear 40 was manufactured in Wichita. Although I guess it might be hard to get what's the name of the certificate you need to prove of origin on an aircraft that's no longer in production? Okay, we've got some, and Brad Harris has raised that question as well. Okay, here's a question from Brad Sheen on the helicopter side. If a Canadian sells a French-manufactured Airbus helicopter for import into the US, no tariff would apply, as I understand it.
Correct.
Until we get tariffs against France.
Also correct.
Which is Jonathan, in your opinion, are we likely to see EU tariffs? It seems quite likely.
I don't know. Tobias mentioned these reciprocal tariffs. So the U.S. Trade Representative sent out a notice. They published in the Federal Register asking U.S. companies to comment on, areas where foreign countries had tariffs that were different than the U.S. tariffs. And by tariffs, I think they meant, any other discriminatory treatment. So, I would take the position that if you bought a French aircraft in France and there was a 30% VAT and you import it in a U.S. aircraft into France and there's a 30% VAT, there's no discriminatory practice, so there's no tariff. But on the other hand, if you say, well, no, that only applies to the imported aircraft, that's the type of thing where I could see reciprocal tariff. I don't know. I don't have a crystal ball. I would hope that what we'll see is not these broad tariffs, but more targeted tariffs on specific products.
Okay. Does anyone else think they're likely? Ehsan?
Yeah. I think so. I don't know how long they'll last, but it's certainly some of the stuff that we've seen come out of Falcon in terms of concerns that they have in their recent investor conversations that they were having after their earnings report. The CEO of Falcon was talking about was talking about those risks and what it represents for them. So, yeah, I don't think they're going to be safe from it. I mean, Canada and Mexico are the United States' closest trading partners. Canada and the U.S. have been the closest allies. Our trade imbalance is largely owed to the fact that Americans buy a lot of crude oil from Canada, and so if you take that out of it, we're actually net consumers of American-produced products. And so, if we're not safe from the pen stroke, I don't see why Europe would be. But that's an opinion, not based on any paper that we've seen.
Okay, and talking about papers, someone is saying, Ronnie Frank is saying, beside industry experts like you guys interpreting what the government announced, is there any office or department where foreign clients can address to get a formal reply? Jonathan?
If you talk to people that import aircraft or other brokers, the CBP, the process in one port maybe in one airport may be different than in the other. So it might be that you work the process, in that place, if you regularly import in a particular place. I mean, there are processes with the CBP to get advisory opinions, but and certainly there's a whole process if you believe that you've been assessed in error to protest, to protest the imposition of a duty.
Okay. Okay. So Josh, yes. Sorry, Ash.
I was just going to point out that both like Canada's response has solicited that kind of feedback, not in terms of what they should avoid imposing countervailing tariffs on. And it sounds like the U.S. is also engaging in a similar process, but more to discover where there are opportunities to level the playing field. And certainly from the manufacturer perspective and the conversations I've had, one of the concerns is having Canada attach retaliatory tariffs that apply to aerospace products, which then will hyperinflate the cost before you even get to the point of tariffs applied on importation on the finished product. And so that's a process that the Canadian government is currently engaged in. And there's a link available for if anybody's interested in providing that sort of feedback. But as far as I know, I mean, they are the institutions, the processes that exist to get determinations in Canada. In our experience, they're not very expedient when you want a binding ruling, and so that's not something that we're accustomed to in aviation, certainly business aviation.
Okay, we've got lots of really interesting questions. If anyone would like to come on and speak, please just put in the chat and we'll invite you up. Okay, we've got a question. So many questions. Here's a nice one from Mike Francis, if the registered owner is a US OT on a Bombardier product, but the ultimate beneficial owner is a non-US person, and the plane is based outside the US, would a tariff apply? What's a US OT?
So I believe if it's imported into the US for consumption, yeah, it's going to be the importer of record that has to pay the tariff.
But to be clear, if you're if you're the movement of aircraft in normal course of business, as instrumentalities of international trade, they're not merchandised. So if he's just flying into the U.S. because once every 3 months he has to come to the U.S., there's no permanent entry. He's not entering it for consumption. No tariff should apply. It would only be if he's bringing it in, as we've discussed before, for consumption as merchandise that's being sold in the U.S. or in these sort of other cases like repair in the United States.
A good point.
Okay, so if I'm in Singapore and I'm buying an aircraft and a Bombardier and I want it registered on the NREG, I don't need to import it into the States.
Yeah, those are two separate processes. That was the distinction I'm making. There's the aviation regulatory side, and then there's the customs and revenue aspect of it. And you'd be shocked. Those government departments in Canada, I'm sure in the US, they don't talk to each other. So,
Greg Miller's got a comment saying 2 Rolls-Royce K engines are being held by US Customs, asking for over $1 million in tariff. Anyone want to comment on that?
They're Canadian?
Well, maybe Greg will come back with that.
This maybe the one point I'll make, and this goes back to how different offices will interpret and apply things differently. That can also be a factor as well. But maybe they're just coming back from overhaul in Canada, and so that's the basis. That would be bizarre because it wouldn't even be products of Canada. But this is the other thing is with the regulatory nature of civil aviation. You can't substantially transform an aircraft like it's based on the type certificate that was issued by the manufacturer, and the manufacturer is based where they are, and the type certificate is owned by the manufacturer in that country. So that's the real oddity when you combine civil aviation with the way that these tariffs are being proposed and imposed.
Greg's saying the Rolls-Royce T engines were repaired by Standard Aero in Canada and now complete with repair and going back. And actually, that's what Jim Simpson's asking. What about engine overhauls performed by Rolls-Royce Canada under the Rolls-Royce Corporate Care Program? In theory, they should be. Jonathan, you're looking. In theory,
in theory, if you had and I don't know that I have a definitive answer, but in theory, if you had a product, you sent it to Canada for repair, then the duties would be on the value added. The 25% would be on the repair, not on the value of the engine. Yeah. If the engine was, that would be my initial view. I would want to look at the facts more closely.
Although, from a tariff point of view, if the engines are not Canadian, Tobias?
The engines are not Canadian, but the parts and labor that were paid for the overhaul in Canada are.
Okay. Another question is, how do tariffs impact the engines being shipped returning from a shop visit from Canada, Mexico? It's a similar question.
I think the answer is the same.
Okay.
It would likely be the differential, the expenditures that they've done to improve the asset. And this is now I'm getting into Jonathan and Tobias's area, but based on the orders that were published on the Federal Register, there was a separate allocation for this kind of differential calculation of the value of the input versus output.
Yeah, I have not looked at this issue as to see whether there's some argument that if the goods are conforming goods under USMCA or otherwise not of Canadian origin, if there's some other exemption, I don't know the answer.
Mm-hmm.
And Jonathan, I want to say I'm disappointed because you have had 12 hours to learn this. And Tara Adkins is saying, at what point will we receive clarity around whether components will be subject to tariffs or be treated? Well, does anyone have an idea?
So the issue, and maybe somebody will publish something, but the issue is that with respect to the way and I don't know, the way the USMCA works is if the goods are either sort of wholly produced within the US, Canada, or Mexico, or if they're produced with non-conforming goods parts that were produced non-originating materials, then those goods satisfy the applicable country of origin requirements. And in the case of aircraft, it's to just give you an example, a used aircraft would be under Harmonized Tariff Code 880220, right? And the way the USMCA works, it says, for rules of origin for conforming goods, that would have to be from a subheading other than that subheading. Mm-hmm. So but the truth is the subheading only covers aircraft. So anything you put in an aircraft is not going to be classified as an aircraft. It might be classified as an aircraft part. It might be classified as a seat used in aircraft. It might be so you don't have to go through that analysis, but you go through the analysis on, say, engine parts, and you might end up, depending on, having to do what's called a regional value calculation to determine if at least, and there's two different methods of 50% to 60%, anyway, to figure out whether the regional value exceeds 50 or 60% based on the methodology. So I don't know that we have a definitive answer on parts. I would say I think that's more of a case by case basis, unless you can say, yeah, we cast this part in Canada, so.
Okay, it's amazing how complicated. Let's just do some really. I think we've semi-answered these, but let's just, to someone just joining, there's a great question from Frank Janet. To summarize, if you're a US buyer up until April 2, if you buy a Challenger or Global or a Bell, you pay no tariff if you check yes that you qualify for USMCA. Is that correct, Tobias?
And provide the certification, or be prepared to provide that certification that it, the form. So just checking yes doesn't get you there 100%, because customs is going to say, okay, where's the certification?
Okay.
Yeah. And the certificate of origin, I think, is what they would need.
And after April 2, will you need to file USMCA?
No.
Perhaps.
That hasn't
wait, go ahead.
That hasn't been made clear. So the exemption that's been provided yesterday, that's effective today, is for goods that can qualify under USMCA based on having a certificate of origin.
Okay.
Which industry hasn't previously had to issue because it was a whole different global trade agreement that applied to this.
So we don't know completely.
Yeah, so we don't know after April 2nd whether this exemption will apply, whether it will continue for the USMCA products. And then the other thing to, again, go back to is that the April 2nd date wasn't stated in the order.
Yeah.
So it was mentioned.
So we don't know and you might have to pay a tariff amount. If you take delivery of a brand new Global now and you fill it with maple syrup on the flight over, what happens? No, don't worry. I like the fact you pretended to.
No, you raise a good point, which is, Tobias and I were talking about this morning, is sometimes, particularly on used aircraft, you're bringing the aircraft over, but there's spare tires or there's a spare whatever. And those, in the past, maybe customs was less worried about them because they were, generally speaking, duty free. But now you would want to go through and enumerate, and figure out where they're from and whether they qualify.
You might have to make a separate. You might have to make a separate entry.
Yeah.
For those goods, whatever they are. The port of entry is, going to have some say in that. They might say, itemize everything, classify everything, make entry for everything separately because they are different than in the airplane itself. They might say, just attach it as an appendix to the entry and list the good. You just don't know.
That sounds like
you want to have that discussion with U.S. Customs before you arrive.
Yeah.
What do we do about spare parts? What do we do about all these other things that we're coming with?
Otherwise, you could be in a sticky situation for that maple syrup.
Very good. Thanks, Ed. Got a question from Josh Tremaine, which we've covered, but let's go back through it. Does a US-Canadian aircraft previously imported into the US that is being re-imported have a 25% tariff? So if you chose to take an aircraft, so you've got a pre-owned aircraft that's been imported once and has gone out, do you have to import it back in?
Well, if it was exported, years ago, and now it's part of a transaction and it's coming back in, I think the answer is yes.
So yeah, I agree. There might be some limited exceptions if it, certainly if it was out for less than a year, or there are some specific provisions for returns, like goods off lease. But again, it would have to be the same. I think the same exporter as importer. I would say you're probably going to bring it in under USMCA. If you can get it in duty free under USMCA, you go that route.
Just one thing to add on that: the oddity between Canada and the U.S., because they're such close trading partners, is that we don't export to each other. So there's no export filings required when an aircraft leaves Canada to go to the United States, and vice versa. So this has come up a few times where, the aircraft was imported into Canada. Technically, that's considered exported from the U.S., but those systems don't necessarily talk to each other, because prior to February 1st, this was all just a statistical exercise of tracking trade balance. And they did it solely on the basis of imports from each other's country, from Canada and the U.S. And so that also raises another complication of, was this aircraft exported if no export was filed on its departure in either direction?
Okay, here's a great question from Scott McCreary. What if parties simply don't properly identify the import for consumption and sale? Is a future buyer at risk if tariffs were owned?
Absolutely. Yeah. I mean, absolutely. And if you didn't properly, if you didn't enter it, particularly if you have an exemption you could have used under USMCA and you didn't properly file, you might get tagged. Well, I guess the question is, who's the importer of record? But it would certainly be, it would be considered smuggled goods, presumably.
Okay. Can you comment on engines, Pratt & Whitney Canada, that are installed on a new used aircraft being imported into the US? This is Mike Swartz.
Well, my view would be that the aircraft coming in, if you put Pratt & Whitney engines on a Gulfstream aircraft, you've got a Gulfstream aircraft, not subject to duties. If you're bringing in a Pratt & Whitney engine, at least my analysis last night, a Pratt & Whitney Canada engine. I know we agreed not to talk about specific manufacturers, but that it again, because of these tariff shift rules that are specific to the USMCA, any item you're going to install on that 8411, harmonized tariff code 8411 engine is going to be from a different tariff code, and so you're going to end up qualified under USMCA. It would be if you've got some subassembly that was manufactured, an engine subassembly manufactured in Canada with parts that came not from the US or Canada, where it gets, the analysis gets tricky.
Okay.
It's more of an upstream supply chain issue there, right? On those aircraft that are using those Canadian products, and whether they're able to, but that's more of a new engine going on a new aircraft situation. But if somebody had to order a replacement engine, they'd be in the same boat, where they'd have to fall under this exemption up to April 2nd and get the certificate of origin for the engine before it can come in duty free.
Tobias, what about a Canadian registered aircraft manufactured in the US or elsewhere So if a Canadian buyer's got a Citation jet or a Leonardo helicopter, and they sell it to someone in the US, there's no tariffs involved.
Okay, so a U.S. manufactured aircraft registered in Canada,
or Mexico.
Okay, or Mexico, but be a U.S. manufactured aircraft coming from someplace else, imported and being purchased into the U.S. That's the question. Okay, so that would just be a normal duty-free consumption entry where we'd get a bond. It'd be a $50,000 bond. We'd have the merchandise processing fee, likely capped at the 634.62, whatever that number is now, and it would be pretty straightforward. No tariff, in other words. U.S. Right. It's the country of manufacture. U.S. manufactured, it's not going to have the problem.
Right. You're going to have to remember, we had a question about if a buyer if an aircraft had been imported, then exported, then imported. Anton is asking, what if it was the same owner?
Oh, I think to Jonathan's point, you got to look at the circumstances, because if it left for less than a year, that was a temporary export, and now there's no, so you wouldn't have an EEI filing for the export, and likely not a formal entry coming back in. But if it was exported permanently for a year or more, that's a good question. I'm not sure I know the answer, but I want to think about that one. Jonathan, what do you think about that one?
Yeah, unless there's some, again, there are, they're putting aside, if USMCA wasn't available, I would want to look through the exceptions that were eligible under the March 4th orders, but to see if there's some other other exception you could use. But again, if you've got a USMCA and it's available, I mean, again, I would look at it carefully, but that's probably the answer, is if you can bring it in duty free in some manner that's lawful, that may be the route to go.
That's a tough one. I want to think about some more.
Yeah,
it's fine. And you can also, people can pay you for your legal advice, or all this. For an international transaction not involving importation into the US, but using a US escrow agent, is there any implication?
I don't think so.
Great. Here's an interesting question someone's asking about. Are there any issues with aircraft manufactured outside the US but completed in the US? Outside but completed in the US? I think this applies to they've mentioned the Gulfstream G280, but there's also the Falcon.
That's a good question. I would take I think the answer is, if you had a G280, or I think there are some Canadian aircraft that are completed. The question is whether there was a substantial transformation into the finished product in the United States. So I think once that aircraft is completed in the United States, I think the answer would be, that completion process is usually is a fairly substantial process. It takes several months. There's a lot of engineering and installation. I think there's a clear argument that substantial transformation. So you would have a U.S. good at that point.
Yeah, but also before it comes into the U.S. for completion, you can be certain that green 280, if you will, is imported when it crosses the border.
Yeah. Yeah.
Yeah.
Okay.
Under bond, with an entry, formal entry, and so forth.
And in terms of just future possibilities, so as a result of yesterday's executive order, Canada has suspended the planned implementation of the next round of countervailing tariffs, which included aircraft. So the first set of retaliatory or countervailing tariffs did not include aircraft. They only included some things associated with unmanned aircraft. So that's going to be another complication that if this continues to escalate, then U.S. aircraft manufactured, U.S. manufactured aircraft could get caught coming into Canada. And all of the supply chain implications of parts or components of aircraft associated with that.
Okay, so you just answered Josh Messenger's question brilliantly. We've got one from a specific one from YYZlaw. If we check yes on the USMCA form, would we be able to use our 50K bond and not a higher bond, Tobias?
So the checking yes is on the entry that the customs broker is going to make. We need that certification. If we have USMCA certification, do you need to get a higher bond because the tariff is still in effect?
So this was something that you and I were discussing earlier, right, Tobias, in terms of the percentage of bond that you would need, and that being potentially in the hands and the discretion of the office that's importing it.
Right. So you've got a. That's a good question, Gary. I want to think about that one as well, and I want to talk to Steve in our office and see what he thinks. Yeah, because you might have to go to your if the bond is insufficient. I don't know.
Do you know what? I don't think anyone's expecting you three to have all of the answers. I think that's
yeah. I'm just thinking through that one, because if you have USMCA treatment certification, then it qualifies for duty free. Right. You've made the certification. I'm going to lean towards you don't need to increase your bond, but with the caveat that I need to double check that and get some other people to weigh in.
Okay, that's great. Ehsan, would maintenance or pilot training delivered in the Canadian be subject to tariffs?
No,
because the point of sale is in the US.
Well, the maintenance bit we talked about in terms of if there's a value paid for on importation, then that's where it could apply. But in terms of pilot training services, no. I can't imagine how that would apply.
Okay. Bonus question from Scott McCreary. Do the tariffs attach to the aircraft or to the entity that owes them? So if in my example, the initial buyer owes the tariff, would a future buyer risk the government seizing an aircraft the initial buyer no longer owns? Jonathan, you were quite clear on the last one.
I don't know the answer to that question. I mean, the importer of record would be, whether the customs could go after the aircraft later. I know there are some odd, customs seizures of aircraft that have been used in drug cases where, you then get into this question of knowledge. Did the bank, is the buyer an innocent buyer, or is there some other? But yeah, I don't know the answer. I think.
Do you know what? It's we've got someone.
I think buyers need to do their due diligence and make sure that the aircraft was properly imported, and before they close.
Okay, we've got to the end of an hour. Do you guys have 5 minutes left to go through the last?
I'll have as much time as you need, Al.
I think you're going to be here for all weekend.
And there are a couple points that I think might be general points that might be useful to make.
If you've got 5 minutes, that would be great then. So, Ehsan, is that all right with you?
Yep, that's fine.
Yeah.
Gary has said, can we talk about using an offshore registry as a workaround and the long-term, short-term pros and cons? Is this great news for Aruba, Bermuda, Cayman, San Marino?
Well, as Ehsan pointed out, registration is and importing, are mutually exclusive processes. So even if you put it on a foreign registry, if you're still a U.S. buyer and you're bringing the airplane into the U.S. for consumption, you still need to import the airplane.
Yeah.
So I'm not sure if that's helpful.
Sorry.
Oh, I was going to say, if you're temporarily leaving it offshore and only occasionally flying it, there's some case law. Yachts have historically been subject to fairly high tariffs, and so I know there's this practice for some yachts where they register them, they keep them in the BVI or somewhere, Bermuda, even though the owners may be in the U.S. But once they if they're being used primarily, within the customs territory of the U.S., they can get tagged. And so someone would have to do the analysis, but I certainly wouldn't think of it be a good thing if the person's going to be regularly flying into the U.S. and living and based in the U.S.
But if I'm a U.S. buyer of a Canadian aircraft or helicopter, and I think there's a chance the tariffs won't last, it's not. I could park it.
Yeah,
and not bring it into the States as a short-term solution.
Yeah, so this is some advice or not advice, but conversations with Canadian manufacturers that I've had is that those owners who are taking title to their new aircraft and they didn't want to deal with this and wait and see sort of approach. They could park them with Canadian management companies. They'd be registered in Canada. And as long as it's intended for export, they're not getting consumed in Canada. They don't incur the Canadian taxes. And from an operational perspective, somebody can bring in a U.S. registered aircraft and fly into and out of Canada without incurring Canadian taxes, even if they are a Canadian resident. And I think the same treatment would be true. So if you live in the States by the 49th parallel, maybe this is a convenient solution as an interim step. But it means that your plane isn't down the road from you. It means you're parking in Canada and it's coming to pick you up. And that would only apply to long-haul assets. It wouldn't apply to smaller aircraft.
And also you could be subject to Canadian luxury tax.
No, because you wouldn't be consuming in Canada.
Okay, sorry. Okay.
Yeah.
Fred Laurie is asking, what about services? Are cross-border services such as sales brokerage or financing subject to tariffs?
I don't think any of those services are subject to the tariffs are on the goods. That's my initial view. I can't imagine that a service. Yeah.
So we're in this interesting transition where now services are crossing borders. So like Netflix is offered to Canadians and Airbnb service, like all these different services. And so historically tariffs always applied to goods. And so I don't think the world has come to an agreement in terms of how they're going to deal with services. And previously it was just based on where you generated the income from and where you reported your income. So currently, Fred, no, these tariffs wouldn't apply to it. But maybe possibly down the road, this is something else that this administration looks at.
Okay, so we've got lots of questions on. We're nearly getting through. You guys are doing brilliantly. Thank you. Mike McCracken is saying, so if a global is complete in the US, even though manufacture in Canada, is that a significant transformation? No. And another question, very similar from Jason. For completions taking place in Canada on used aircraft originally manufactured in the US and being sold to an end user in the US, can you confirm if the new parts put on the aircraft sourced from the USA within the last 3 years is exempt from tariffs?
So that's an interesting question. I had this discussion yesterday. I think it's possible that you might be able to make the case that U.S. source parts can be deducted. And, you have to have the cost of those parts can be deducted. But you have to have, record keeping to show U.S. Customs, we're deducting the value of these U.S. parts from the from the amount that's subject to the tariff, and then they get imported as U.S. goods returned. So you still got to make an entry for those. You still got to have record keeping. You still got to make the case why you're deducting the value of those related to what's being imported.
Right.
And that's,
I would just say on that one, if
that is going to be super organized if you're gonna take that approach, and so you're driving down the cost of the tariff, but you're still going to have an added expense.
Mm-hmm.
Again,
does that make sense?
It does. You guys are doing brilliantly. Samuel Winderow is saying, could you also cover what applies to software? We've talked about service purchases. Software and non-physical goods.
I don't have an answer on that.
Okay.
You'd probably have to look at the tariff schedule, and if it's coming in some kind of physical medium by way of like a CD-ROM or a hard drive or something, then maybe it falls, but we'd have to look at the specific tariff schedule.
When's the last time you used a CD-ROM? Come on. Like, or a Betamax tape. Chris Brenner has gone, on cross-border transactions where tariffs apply, is it the physical closing date or just the date of import that applies? Tobias?
Okay, so if a tariff's going to apply to an import, the aircraft shows up in Bangor, Maine. Date of import is March 15. The importer of record has make entry, have to have a bond, all that, file the 3461, 7501, et cetera, and the tariff is due in 8 days. And generally the tariff is received by the customs broker, and then it's paid on their behalf.
Okay, and we've got a fantastic. The questions. I think this will probably be the last question, and then I'm going to let you go to closing remarks. Jason has said, do we know if completed aircraft from Canada shipping to US government agencies, state and federal, also fall under the tariff schedule?
I want to double check this, but I heard that there was no exemptions even for government agencies.
Great. I just, on behalf of everyone, I think David Mayer's asking, do unpaid tariffs create a lien on the tariff assets? E.g. import without paying correct tariff amount. You think that does happen? Yeah, Jonathan thinks it does.
I think so, but I haven't looked at that specific question. I would think it would be, generally the definition of liens and encumbrances, an unpaid tariff would generally under a purchase agreement be. I would consider that, but again, that gets to the point of who's responsible for paying that under the purchase agreement.
My big concern is that while we've been sitting this, no one's been checking CNBC. So we don't know what's happened since. You've been amazing. The one question I had is, if I'm an existing owner of a Canadian aircraft, could I just bring in the new one and switch the transponder and the nameplate and not worry about this? We've got so many people saying nice things to you, saying thanks so much for doing this. Jonathan, any thoughts you'd like to sum up?
Well, just two quick things. One is we didn't talk about the aluminum and steel tariffs that are going to go into effect on March 12th unless something happens, which I don't think will have any direct effect on sort of the data. It may affect manufacturers, and the reason I say that is that the aluminum and the derivative items that would be subject to this additional 25% tariff largely exclude, I haven't done everything, but largely exclude aviation for civil aircraft. So if you've got a refrigerator made in Mexico, the aluminum content would be subject to this additional 25% tariff, but for USMC, yes, would be subject to it, and but there's no such equivalent for, say, a interior door on an aircraft. And then the other thing I would say is we've been getting a lot of questions about the the purchase agreements, and historically, purchase agreements have not, force majeure. Sort of, if you think about it, you add a 25% tariff, it changes the agreed to bargain, and so thinking about creatively going forward, whether you make your force majeure clause include a material change in tariffs, or rather than try and put the duty on one party or the other, or anyway, so that was just a thought, because that issue's come up.
Which is amazing.
I would add to that, and I think I mentioned this in London now. We've been operating in this duty-free environment forever, and the documents in the infrastructure in our industry, document infrastructure, hasn't really addressed this issue. It just hasn't had to. But purchase agreements, lease agreements, loan agreements, trust agreements, they should all be refreshed to address these issues to the extent they can be. I think that's an important thing for everybody.
Ehsan?
Yeah, I think in terms of the language and agreements, conceptually, yeah, we should totally address it. But when you get down to the weeds of negotiating between buyer and seller, that's when it gets really complicated. In terms of what this is going to mean more broadly for our industry, I think the supply chain impacts at every level, whether it's the cost of aluminum just going up because the supply chain is constrained as to where different manufacturers can source it, that will result in higher costs. The potential knock-on effects of components getting tariff treatment is going to increase costs. And overall, I mean, if these tariffs do stick around, the business aviation marketplace will be constrained within the U.S. and outside the U.S. And so whatever is in the United States will now be relatively cheaper. And I just look at these from a mission profile perspective. So a Bombardier and a Gulfstream, if they perform the same mission, there's a topical difference between the two. And in terms of pricing, if you're an owner within the United States and you have a Bombardier and you know that the market has just gotten 25% more expensive, then you'd be well advised to increase your price and to take some of that difference for yourself. And so I think these inflationary pressures are going to they're going to slow down our industry. They're going to slow down transactions, and we've already seen it in the last month and a half. So it's here today to give some information about what we have and to keep this conversation going.
You've all been brilliant, and I know you're probably the busiest people in the market keeping up with it, and I'm amazed at how quickly you've all revised USMCA in the last few hours. Final question: can we pencil you in for April the 2nd, please?
Absolutely. Yeah.
or April the 3rd. Thank you so much. You look at the comments. We've had more than 400 people joining us today, and we're really grateful. So thanks so much to Jonathan Epstein. Thank you so much to Tobias Kleitman, and thank you so much to Ehsan Monfared. We're really grateful, and stay safe, everyone. Thank you very much.
Awesome.
You're welcome. Thank you.